So welcome to our first episode of Patent Insights. This is the YouTube series that is powered by depa.tech and Moving Targets Consulting in the Berlin-based companies. So welcome again, as we are so happy, so exciting to launching this YouTube series called Patent Insights. And this is Mustafa. I am patent owner at depa.tech, and also I am the co-founder of patenteffect.com. And these Patent Insights is designed and published to support patent professionals, innovation experts, R&D specialists, to support you to become a better patent leaders in your industries, in your ecosystem. So that's why we are producing weekly patent-focused content in our newsletter called Patent Insight as well, in the same name. And we are really happy to initiate this YouTube series, bi-weekly YouTube series, to support or to make more visible in different industries. So the first episode of this event series, the topic of our event today is top 10 patent cases happened last year, happened 2022. So there are lots of notable patent cases, regulation changes, litigations or licensing agreements or new initiatives happened in last year. So these are all patent-focused news, regulation changes, and other important cases in the patent ecosystem. So today, to discuss these topics, to discuss these top 10 patent cases in 2022, I have so distinguished speakers from different countries. I have two speakers from BARDEHLE Pagenberg from Germany, Munich, and I have one speaker from FINNEGAN, Anthony Berlenbach. So I will also invite them to join in the live session together. And today we will hear from them different cases, different topics in the patent perspective. So before starting and before inviting them in the stage, I would like to make a quick reminder for our audience. As you know that this streamline is live on our YouTube channel. So you can ask your questions, you can make your comments, any suggestions in the chat section. Please use the chat on YouTube and then write down all of your questions and comments. So after each speaker slides and speech, we will have a question and answer session in 10 minutes. So I will read and I will help to moderate these questions and remarks from YouTube chat section. So I don't want to make late this live session, and I would like to invite our speakers to the stage, to all of them. So I can invite Preston Richards from BARDEHLE Pagenberg as a first speaker, but I will invite all of our speakers on the stage. Preston, welcome.
Good afternoon. Thank you for the invitation. Nice to be here.
It's our pleasure, Preston. Thank you so much. And another speaker, second speaker from BARDEHLE Pagenberg from Munich, Anita Peter is with us now here. Anita, how are you?
Also thank you for the invitation.
It's our pleasure that you accepted to be here on the stage. So the third speaker from United States, from FINNEGAN LLP, Anthony Berlenbach, is now on the stage. Hi, Anthony, welcome.
Hello, yes. Thank you for having me. I'm looking forward to our discussion today.
Thank you so much for all of you to give your time and effort and support to our first episode in Patent Insights. So I'm really happy to hear your notable patent cases happened last year in different perspectives, from the Germany perspective, from Europe perspective, from United States perspective. So it will be very exciting to hear your speeches. So before starting with Preston, I would like to remind another thing that you can see on the screen as well. We are publishing and making announcements for all of our content and every events, online events, in our newsletter, depa.tech.substack.com. So if you want to hear our newsletters, weekly content, and online events that we are organizing in the upcoming weeks, please join us as free of charge, so you can get updated in a weekly basis. So just a reminding, and I would like to start with Preston. And I think the weather in Munich is good as Berlin, right? Today, how is the weather now?
Oh, can't complain for a middle of February, middle of March, but yes, it could be better. Uh, Hopefully, the spring comes quite soon.
Exactly. We are looking forward to have the spring as soon as possible. So, Preston, I think you can share. So, you have already shared your slides, so we can make it visible on the stage now. And this is your slides. And I think we are ready as a technically and make this presentation like that, and I am giving the stage you, Preston. So you have 20 minutes to share your notable patent cases for this session. Stage is yours.
Thanks, Mustafa. Well, I'm not going to share 10 cases. What we have decided to do is sharing among ourselves a number of cases. What I would like to focus is the cases from Europe, in general, EPO and related European cases. And these are my top three. Doesn't have to be cases; they are not cases by itself, but the top three topics that I will start with. Um, the first and the foremost elephant in the room, UPC. Um, Everyone has been talking about it. Of course, right now the steam is picking up. We are in the sunrise period. Uh, Back and forth, everyone is preparing for the UPC opt-in, opt-outs, preparing lawsuits. But we are here. What I want to say, talk about is not just what are we doing now, but how did we get here, and why is this important? Yes, this was top 10 from UV from 2018, and you can see it was one of the top 10 at that time. And why is it still a top 10 in 2022? Because this case or this UPC uh, uh, episode has been going on for ages. It started in 2013. Many countries had ratified it, but then 2017 we had more. So what is the situation? Generally, right now the provisional application phase is over. The sunrise period is started, so that's the part there. We are in the 3-month period. This looks straightforward, isn't it? But there has been a lot in the meanwhile to get to that point. What I will show you is before the sunrise period. I don't know if you can read clearly, but the issue started with the Germany and ratification of the UPC. Of course, a lot of countries already had ratified it, but Germany hadn't. In 2017, it was going to, but then a constitutional complaint came up. And you can see 2017 is when the complaint started. It took some time, and in 2020, the German Constitutional Court ended up upholding the complaint and said, "Oh, well, this is not really suitable." But that was mainly for more procedural and what we would call a more uh, it was not a legal question, but more procedural issue of why it was not constitutionally compliant. And then the German government said, yes, no, we are going to push forward through it. And in 2020 they ended up pushing forward. And again in end of 2020 you ended up having the Bundesrat which approving the part. And then the complaint came. But again, it wasn't over. The end of 2020, a second complaint came up after the new one was ratified, and at that point, uh, you had the decision come up. But that didn't take long. The last one, you can see, it took 3 years for the Constitutional Court to uphold the complaint. This time, the complaint just took about 1 year, 8 months, when the German court ended up saying no, we are actually rejecting the complaint. So in 2021, end of 2021, the German court gave the green light for the process in Germany to start. So that was even before the provisional phase. What happened last year? Uh, in January 2020, um, when the 13 member states had ratified it. So in the UPC, you had this condition where you can start the provisional application preparatory phase once there are 13 countries. And Austria was the 13th country to actually ratify it. It was in January of 2022 when Austria deposited the ratification, and the the process at the UPC started. So 2022, early 2022, the preparatory phase starts. Immediately, the EPO says, "All right, you're preparing for it, and we are going to give you provisional measures where you can already start taking up." So, what were the provisional measures allowed by the EPO? They ended up saying, you can postpone or move your you can postpone or wait for the grant of the patent, because if it's granted and if you end up doing it, it might be granted before the UPC sunrise period starts, which means you might not be eligible to enter, or you might have the issue of trying to go. So it's like to directly go to the UP patent. They said, all right, even the cases where it could be granted, or the so-called 71.3 communication comes up, you can say, no, please hold on the 71.3, wait for some more time, and move. Let me give the 71.3, that is allowance for grant, in a later stage. So you could postpone that. The second thing EPO said at a later stage was when the preparation was a bit more in advanced stage. They said, oh, we know that it might start soon. So now you can actually not just postpone the 71.3, you can actually agree for the 71.3. We will not grant till it's there, but you can agree for the 71.3 with the condition that you want it to be a patent. And therefore, you could go the way of saying, when the preparatory starts, I will be going to UP, and EPO provided that measure. So you had two different measures available. Um the UPC Administrative Committee also started, so the preparation phase started, which meant all the rules of procedure had to be confirmed. Then the question of who can practice in front of UPC was confirmed, and then the question of which are the certifications which can be valid, those were confirmed, and later, finally, they end up having uh, they end up putting a judicial appointment. So they ended up saying, "All right, we have the judges." There was a period of time when judges were being considered. I think it was from 2019 onwards. There were already applications open, but in 2022, December of in October. October 2022, they ended up confirming the appointment of judges, and then it was all ready. But as per the UPC agreement, Germany was the last gatekeeper, because there were two requirements. One is 13 member states to ratify, and the second requirement was the top three patent application countries had to deposit. So these were the two conditions to be met. 13 member states ratified with Austria, but Germany was waiting, because Germany was one of the three. In fact, it's the biggest patent holder now. It was always the biggest patent holder, of course, after the Brexit. Uh, Germany was the gatekeeper to make sure that once they ratify it and once the ratification is deposited, the sunrise period starts. And then the sunrise period issue started because there was a issue with the CMS, that is the content management system, where you can, a case management system where you can do it. So they ended up, or the UPC administration ended up saying, oh, well, maybe it's not really time to push it, because people are not used to it yet. You had to get a signature, and therefore we will wait for the period to kick on. Germany could have, the initial idea was Germany ratifies it before December, which means the sunrise period starts in 1st of January. But then they decided, no, we are not ready. The users are not ready, and therefore we will wait for some time. So the wait was for 3 more months, and in fact they did ratify it and deposit it on 17th of March, which means that the sunrise period already started from this month. So last year was a lot of news coming up with UPC coming where it started. So right from 2013 to the complaints being not taken up by the courts, to the UPC preparation actually starting and the rules being confirmed, to the sunrise period starting. So we are hopefully at the end of the tunnel. I remember from the time of 2008, there was talks everywhere. 2013, when it came up, it's like, okay, now it's coming, it's coming. So you can see all the reports right from 17. It's like, oh, it's coming next year. Yeah, in 18, it's like next year. So the top 10 cases of this year is like UPC is coming. Next year, to look forward, UPC will be in look forward. Finally, I think this is the year when we can say UPC had come, and we can end up saying this is what we are looking forward to. So that would be the first big case, big change for us as practitioners in the EPO European sector. The second is AI Inventor. Yes, don't tell me this is so 2022. Yes, it is so 2022. But the question, in fact, the issue was going on for 2 years. 2021 was when the courts started hearing it. A lot of question came, but 22 is when the courts published their decisions. So I would take it more into 22 because we had two things. One is the German court, or the German Bundespatentgericht, the Federal Patent Court, which is actually the appeal court of the patent office in Germany. They took up the case in 2021, and the decision came in 2022 about March. At the same time, the EPO, the Boards of Appeal, took up the case in December 2021. The decision came out in July 2022. So I'm still putting it in 2022 because that's when we knew what happened. There are two cases, J820 and J920. Both were from the same inventor. I'm using inventor in a very broad term because everyone is not sure what the inventor is, but I would say Stefan Thaler, Dr. Thaler is the inventor of that application. So in fact, the two of the cases was filed by Dr. Stefan Thaler, and it was refused by the formality department in the part, because at the EPO, what happens is you can, when you file an application, if it doesn't meet the formal requirements, it doesn't even go to the examination division. That's the second part. So there is a first part where the formality office, they have their own board, formality division. They will give you a decision on the formal issues. If they don't even meet that, to go to the substantive issues which are taken care by the examination division. This case did not go to the examination division because it failed the first step, that you didn't meet the formalities. So there was a decision by the formality division, and they ended up saying you can't have a patent because inventor is not disclosed. You haven't said. And Dr. Thaler insisted always, and still is, that he hasn't invented it. And it was just this computer which came up with this invention based on everything that was provided. So you end up having one question where the application was filed, and in the application, when the inventor had to be indicated, it was always said as Dabus. Anecdotally, Dabus was actually a patent application by itself in 2019. In the late 90s, Dr. Stefan Thaler was an inventor who invented Dabus, and Dabus was a patent application. It did not get granted. It didn't go anywhere. But if you can actually read the patent application, which discloses Dabus, who is the so-called inventor in this case. And Dr. Thaler said, no, we have this invention. It was being done by Dabus, and therefore I morally cannot claim responsibility for this, because the public has to know that it's not me, but Dabus who have done it. And therefore, I want to include Dabus. But then since I own Dabus, it belongs to me. The formality department, of course, said, no, EPC doesn't have any provisions where you can not include a name of a person, but a machine cannot be put there. And then the appeal was there. There was 3 questions on appeal. Mainly, the question was, well, is there a requirement that the inventor is a natural person? And in the EPC, is there something where it says, oh, do I just have to say something, or do I actually have to say what it is? That is, can I just is the compliance of the inventor requirement a mere formality, or it should be a truthful statement in the sense of it? And the third one is, well, does even EPO has any power to check who is the inventor? Because you are not anyone who can check this part. What I say, you should take it as face value that this is what it is. You do not have rights to check. Well, it didn't. Of course, the board did not take it far. The board said no. Well, under the EPC, inventor must be a person with the legal capacity. A machine is not a person with the legal capacity, and therefore it is not a legal person or natural person by the terms of it. There has been debate of what the legal capacity was, but it was clear from the decision that it was meant that only a natural person could be an inventor, and therefore EPC says machine cannot be an inventor. And the argument that the public has a right to know the inventor's identity also did not fly too far. There's no basic right of the public should know who the real inventor is. EPC just says you need the part of it, and that's where we're going to stop. What happened at the German office? That's a bit of a different part, because they also tried in Germany, and what I would say, they came to a compromise situation, where in Germany the applicant said, so you can see the 2 parts. This is the form where you have to provide the information of the erfinder, which is the inventor. In the part on the right, it says not allowed, which is when they said Dabus. Dabus is the inventor of the who had come up with the who had come up voluntarily from based on the AI machine. And they said care of Stefan Thaler, and the German patent court said no. Well, that's not allowed. They also tried to put saying, oh, all right, we will put this, but then we'll put in the description and say, well, it's an AI inventor who was Dr. Stefan Thaler put information such that they invented. Then they said no, the offender form should be clear. So the compromise which came up was Dr. Stefan Thaler is the finder, and one more line later, which says in English translation, it says who caused the artificial intelligence Dabus to generate the information or come up with the information. The question is again, why is this okay? It was considered fine because the German patent office said, the German federal court said, well, we only need the first one. Say whatever you want afterwards. That's not going to be in the form later. You can say that you had caused something else to come, but as long as we have the name, it's good enough. And there was this question of what's caused. It's a German translation of the word. Well, there has been discussion of how the word could be interpreted, but caused did he do something to make it cause, or was it something in the way of, did I just commission it in the way of saying, no, you do it, and it did it by itself, or did I actually make the preparations for it to cause? So there was a debate about it, but in German, at least, that was irrelevant for the purpose of the whole thing, because they said, no, this is not material. We have the name of the inventor. That's good enough. Now we can go forward. Good. So at the end, they had a compromising situation where they ended up saying, yes, you can put the name of the inventor as long as it's there, it's provided. There has been debates going on saying, well, was this a compromise? And because earlier they said, no, I didn't invent, Dabus did, and later come up and say, no, I invented. Was there a paradox in the statement of providing of moral rights? A lot of discussion here, but one thing we want to see, is it over? Well, we hope so, but not really, because there is a divisional application in the EPO, which is filed. And since the division application directly goes to the examination division and not the formality, because once it's this one, so now it's an examination, and now we have to find out how they are going to deal with it, and we expect that the inventor would go all the way to appeal this decision too, if it comes, or they might find a compromising way of trying to put, okay, Stefan Thaler, like how they did in Germany. It's also not over. In fact, only this week it was heard by the UK Supreme Court, which is one of the highest court to take up this case. Of course, Australian court took up, Indian court, Thai court. We have a lot of different courts who have taken up and finished the case, at least, but we have not seen the end of it. We will be seeing a bit more further. The last of my cases, it would be the plausibility standard. This is a bit of a technical question, but I'll keep it very, very superficially brief. At the EPO, what you can do is, if the boards of appeal have diverging case law, or if there's questions that certain cases are using certain standards, certain boards are using certain standards, there is a possibility of filing or requesting answers to legal questions, and this is referred to the enlarged board of appeals. And the decision G221, it's still pending, is one of such referrals where the plausibility question comes up, and we are waiting for it. What happened last year? The oral proceeding came up last year for this G221. We don't have the written decisions yet. In the meanwhile, there has been a lot of discussion going on. We are expecting the decision somewhere in the middle of the year, in general part, anytime soon. But why is this important? In general, the question comes up about evidence. There are two or three plausibility requirement. Ab initio possibility, whereas, well, when I'm filing the application and I'm saying that this is something which I'm going to use as a technical effect, is the evidence already at the time of filing? That is it plausible that a skilled person reading it has already found out in the application as originally filed that this effect is achieved? Why? What does this do? Because the burden of proof now lies at whoever files the application. Because at the point of filing the application, you have to so-called prove that this was plausible, that the effect could be achieved. The second standard is ab initio implausibility. That is, when you file the application at the later stage, you say, oh no, I actually meant that is the technical effect. Was it plausible that that was a technical effect? And now the burden lies on the other party to say, no, well, you couldn't have plausibly said that was the technical effect because we don't know. Or the burden now is switched on to the other side. So was it implausible at the date of filing that this was a technical effect? The first was, is it plausible at the date of filing that it is a technical effect? Proof is on the patentee or applicant. Was it implausible that this couldn't have been the technical effect? Now the proof is on the other party to prove. No plausibility requirements. We will probably not deal with this. Why is this question important? Because when we are filing or doing an application at a stage, the technical effect changes subsequently, because you might be filing something, but then the prior art comes up, and then your invention might be not this much what you thought was, but then a little lesser or a little different than what you had before. And in those cases, it becomes, okay, can I prove it? Because you will not know at the time of filing that this would have been the prior art, and now once the prior art comes up, it would have changed. This could end up being a question later stage. Why is this important? Right now, it's only on inventive step. The question has been raised on, has the technical effect provable for inventive step? There is questions because the same standard of plausibility can also be on sufficient of disclosure. So if the effect was not plausible, was the disclosure sufficiently was the application sufficiently disclosed when it was filed? So it's not just inventive step question, sufficient disclosure, and also novelty. That is, it's not just our application anymore. If someone brings up a patent and says, no, this actually discloses this, whatever you're claiming, how should you look at, okay, what did it actually say what it is saying, or was the proof that this effect is there in the novelty destroying document, or is it plausible that it could be found out in the novelty? So the standard depends not just on your inventive step, it could make up also for the sufficient disclosure enablement. So it's an open question for now. It makes a lot of difference for a lot of things, especially for further medical use cases and also for AI, because at one point a lot of black box cases come up, and then you have to have a plausible technical effect in each of them, and when do you prove it becomes a question. So this would be my 3 cases from Europe in general. Yeah, and hopefully any questions would be there.
Yeah, that's great, Preston. So I think you finished in a very time based. It's 20 minutes. So I made the reminding to our audience to make their, the comments and ask questions about your topics. So maybe before waiting their comments and before switching to Anita, maybe regarding this AI mentorship, I can ask, so can we say that the court decisions will be continued in different countries, because it is not, it's not finished, right? So lots of applications in different countries, and these countries will make a decision in their patent offices and courts, right?
Most of the countries have decided against it. There's only one case where there has been a positive decision, but it was not a decision by itself, because it was South Africa, which is first to, I mean, you just have, it's just a formality question. So there was no examination there. You file it, there was never checked. Otherwise, all the other countries refused it. Australia was one of the country which initially agreed. The patent office refused it. The first instance court agreed to it, and then it was appealed, and the highest court refused it again. So Australia was also went all the way. The only one which is open now is the UK Supreme Court, which is still hearing the cases. Let's see how that turns out. But in the meanwhile, all the patent offices have put up summaries and try to come up with, okay, do we have to answer this question now? It's really relevant, and most of them said no. For now, it's not really a question we need to worry about. Let's see how it works in the future, because yeah, AI inventor is not yet there.
Nice.
I will not comment on the was it an invention, was not an invention, but what of course the question is an interesting legal question. But is it a relevant question for this time? At least the patent officers say we do not have to worry about this for now.
I get it. So please, to the audience, you can ask your questions or make your comments to directly Preston, or at the end of the both speakers, we can also take your questions and comments. So Preston, thank you so much for your valuable input. So I am switching to Anita to talk about other topics chosen by Anita Peter from BARDEHLE Pagenberg. Anita, welcome again. And your presentation is ready to be on the screen. And you have another 20 minutes to share your insights about your selected patent topics. So stage is yours, please.
Many thanks, Mustafa, also for the presentation, for the introductions. Sorry, I will start my presentation now. So for today, I selected just some cases I thought that could be of interest. So as Preston already covered the hot debated topic of UPC, I will focus on other ones. So today, what will you hear or learn from me? First of all, you will learn about 2 main changes in German patent law due to the Patent Modernization Act and first use cases. And then what the German Federal Court of Justice recently found on exhaustion of exhaustion and covenant not to sue agreement, and finally, by way of a recent judgment of the Regional Court of Munich I on the relevance of validity of the patent in suit in PI proceedings. So let's jump to the first topic: Patent Modernization Act in Germany. So there have been 2 major changes. The first is the amendment of Section 83 of the German Patent Act, governing the nullity proceedings before the German Federal Patent Court. So the new version that came into effect on May 1st, 2022, stipulates that the preliminary opinion of the Federal Patent Court must be issued within 6 months after service of the nullity complaint. So a bit of a brief background to this new regulation. Due to the bifurcated system in Germany, where the patent infringement and validity proceedings are heard before different courts, and due to sometimes significant differences in the duration of the proceedings, the infringement court often heard the infringement case long before a decision in the parallel nullity proceedings, or even before the Federal Patent Court had issued its preliminary opinion. So meaning that the plaintiff was often able to enforce its infringement decision and to remove the defendant's product from the market, while the Federal Patent Court months later invalidated the patent in suit in the nullity proceedings. That is to a time when the defendant might already have suffered irrecoverable losses. So this is what we call the injunction gap, and this is at least reduced by this new Section 83 of the Patent Act. Under the new regime, the infringement court now has the preliminary opinion as a sound assessment of the validity still in the pending first instance infringement proceedings, and can decide on this basis whether or not to stay a case due to reasonable doubts on validity. So the new Section 83 also provides for shorter deadlines for the parties for filing submissions, and the Federal Patent Court also has to submit the preliminary opinion directly to the infringement court, so that everyone is informed on the same level. Yes, so what we've learned so far since this new section came into place, that the proceedings as such accelerated so much. So first, we learned that indeed the Federal Patent Court issued its preliminary opinion within 6 months, and I also personally am dealing with a case which seems to be handled within less than 1 year. That's more or less a record for the Federal Patent Court. So, but let's see whether the Federal Patent Court can maintain these speedy proceedings in the future. Now, the second major amendment in the German Patent Act is the new Section 139. This provides now for a limitation of the claim for injunctive relief. As you might know, the German patent law has been known in the past for its quasi-automatic claim for injunction. So whenever an infringement was found, the plaintiff had an injunctive relief to enforce. And in this context, in the past, proportionality consideration played only a really minor role. For example, an exemplary case in which the Federal Court of Justice discussed a limitation on the claim for injunctive relief in the context of principle of good faith was the case Wärmetauscher. Specifically, it was discussed whether a time limit for use should be granted in the case where the infringing product was a minor component of a complex product. However, such restriction was not granted. In the past, the fact that the infringer was threatening by an injunctive relief damage with a particular extent was, if at all, considered mainly in the context of the amount of enforcement security determined by the court. But now we're having the new Section 139, which contains an explicit restriction to the claim for injunctive relief. And according to this section, the claim for injunctive relief is excluded insofar as the claim would lead due to special circumstances of the individual case to disproportionate hardship for the infringer or third parties, not justified by the exclusive right. So noteworthy is that Although the German case law declined in the past to consider third-party interests for restricting the claim for injunctive relief, it was now explicitly included in this rule. If a defendant nowadays raises a disproportionate objection, it must, however, comprehensively demonstrate and prove that the requirements are met. So far, no case is known. So since this new regulation came in place in 2022, where a defendant actually successfully raised this objection. So maybe in 1 year, when we're coming together here in in this forum, maybe I can report about the first case on this section. So then I'm coming to my second topic for today. This is exhaustion and in the context of covenant not to sue. With this decision, CQI Report 2, the Federal Court of Justice recently had the opportunity to deal in detail with exhaustion. In this case, the patent proprietor filed a patent infringement action as regards LTE mobile phones distributed by the defendant in Germany. The defendant raised an objection for exhaustion as the patent proprietor had concluded agreements with the manufacturers of the chipsets installed in the LTE mobile phones. These agreements contain a covenant not to sue, covenant to be sued last clauses, meaning that the patent proprietor committed to only assert rights against the chipset manufacturers after all third parties had been sued. With the appeal judgment, the appeal court rejected the defendant's objection. It was of the view that neither an agreement not to sue the other party for patent infringement nor an agreement that obliges not to assert claims against the chipset manufacturers until all third parties have been sued could be classified as consent to the marketing of the patented product. So in the appeal on points of law, the Federal Court of Justice found that the appeal court's decision is legally incorrect. Although the Federal Court of Justice itself did not finally decide whether the defendant can successfully refer to exhaustion, but referred the case back to the appeal court for further fact-finding, some important legal key findings can be taken from that decision. So first of all, and contrary to the appeal court, the Federal Court of Justice stated that a covenant not to sue leads in general to the exhaustion of rights with regard to the products placed on the market on that basis. So it, first of all, it repeated the established case law that it is decisive for exhaustion that whether the respective products have been put on the market either by the patent proprietor or with the consent by his consent by a third party. In the case of products being put on the market by third parties, the exhaustion effect does not necessarily require that an effective license has been granted to the third party. So the Federal Court of Justice states that the exhaustion is also in this constellation a mandatory legal consequence in case of a product being put on the market with the consent of the patent proprietor. So with the taken obligation to not assert any rights from the patent against the contractual partner of a covenant not to sue, the patent proprietor expresses, so the Federal Court of Justice, in a sufficient manner that the rights with respect to the contractual partner's acts of distribution were exercised, thus that the products are put on the market with his consent. So the less declared reservation to assert claims against the contracting parties' customers for patent infringement is then, so the Federal Court of Justice just, in principle irrelevant. Because with the exhaustion, the patent proprietor loses his possibilities to impact the further fate of the protected product, and this legal consequence can also not be excluded by contract in relation to the third parties. So then the second main finding in this case was that the effect of exhaustion is in principle limited to the product which has been put on the market with the patent proprietor's consent, and does not automatically extend to the devices that contain such a product as one of several components. It pointed out then that a different assessment could be possible, namely that an exhaustion as regards the chipsets could extend to the overall product, here the LTE mobile phones, in the case that the only reasonable economic use of the chipsets is their installation in mobile terminals. So the Federal Patent Court then had two ways of reasoning that. It was stated that the patent proprietor's consent to the distribution of the chipsets could be interpreted also as the consent to the distribution of mobile terminals, and it also pointed out that the technical effect of the patent, it could be a case of exhaustion when the technical effect of the patent in suit is mainly induced by the chipsets, whereas the other components of the mobile terminal are not of importance in this respect. So, as I said before, this case was referred back to the appeal court for further fact-finding. And also here, maybe in 1 year, I can report how this case ended up. So, jumping to the third topic for today. This is a first instance decision of the Regional Court of Munich 1. Normally, we would not necessarily present a first instance decision, but this is of importance because it is a departure of I would say the first decision departing from so far established concept in law. So a brief background: when PI proceedings are pending, the validity of the patent in suit is usually of relevance within the comprehensive balancing of interest. And here in the past, the applicant had to demonstrate that the validity is sufficiently secured and the opponent's objections are unjustified. So, and there's this prevailing case law. It's very famous in Germany. It's Hahn-Katheter Z from the Regional Court of Düsseldorf. Also, many other patent chambers followed that concept. And according to this case law, it was said that the validity is sufficiently for the validity to be sufficiently secured, the patent in suit has to be officially confirmed within opposition or nullity proceedings. So in the past, a potential let's say it like that. Only in very, very rare cases it was possible to file a PI request when it was not such a confirmed patent. So there were only very rare, relatively rare use cases in general for PI proceedings in the field of patents. But now the Regional Court of Munich had announced its decision. As I said before, it departed from the previous concept, and with this it followed a decision of the ECJ named Phoenix Contact Harding, and it the beginning or the main message of this is, first of all, that European patents are presumed to be valid from the date of the publication of their grant. So whenever they are granted, they are their validity is sufficiently secured. This somehow then shifts who has to demonstrate what in the proceedings. So here, under the new regime, the opponent has to reverse this presumption. So it's, as you see, as I have highlighted, who is now who has now to do the job. Here it's shifted the burden of demonstration. Yeah, so this is all, as I said, only not only, but a first instant decision. However, it is very likely that in future all the other patent chambers will follow that ruling. And as I also said before, now the potential patent infringer cannot rely any longer on the fact that the court will reject such a PI request because the patent was not confirmed in such a proceeding. But in future, a potential infringer, it might be a good advice for him to maybe file as a precautionary measure protective brief with the central registry to demonstrate in the protective brief that the invalidity of the patent. Yeah, so that were my 3 patent cases for today.
Super. Thank you so much, Anita. That's really good to see some regulative changes, mainly in Europe and Germany. Thank you so much for your inputs. So maybe asking some questions from the audience to Anita. I just realized that after starting to Anita's speech, we had a question for Preston about AI inventorship. Maybe we can turn back to this question from Udo Gennari from Austria. So I also make it visible on the screen. Preston, I can read it. So the Udo is asking that, is it possible or at least plausible that a false input a person as an inventor instead of an AI using computer can cause a patent being rendered invalid if this fact is known? What should want to say?
Well, I would take this as in two different concepts. One is there is a question of inventor disputes, and that's a very, at least in all the jurisdictions, you have, if someone has falsely claimed invention from some other inventor, there is a method, there's like procedure of how to deal with that. But that starts with the original inventor saying, you have stolen my invention. So the procedure at the EPO or any jurisdiction of where inventor conflict is first someone has to say, no, you have stolen my invention and therefore this should be mine. Please give it to me. Would an AI end up telling or asking for inventor, asking that it was my invention, the AI says it's my invention, files a lawsuit against the person? Because any procedure starts with that process of the real inventor coming up and saying, no, you have falsely taken it from me. At least for now, there's no other way for it to go forward than the real inventor coming up and doing. The second would be, I think, policy and the need basis. One is, okay, does what is the disadvantage or what is the policy constraint of why an AI should be given a patent? And if it's a patentable matter, irrespective of if AI came up with it, if it did, or if it were filed by someone else, the policy matter should be considered differently versus the morality matter. A lot of discussion going on morality, at least based on all the laws which are there. There's no something, I do not know of any law which says if a false information of inventor is provided, the whole patent is gone. Even in the case where there's a false inventor and a real inventor comes, the patent is not gone. It's actually moved to the real inventor. So it was reassigned to the real inventor by itself. the EPO says all these should be done in the national courts, go fight it. Yeah. So at least the laws for now doesn't have anything that I know of. Probably there might be something, but it should be starting with that. Yeah.
Super. Thank you for the answer. Maybe I can remind to our audience, you can ask your questions like Udo Gennari by writing in the chat section to Anita or Preston for our previous speakers. So they are still here. So you don't miss any chance to ask any of your questions to our speakers. So maybe we will have some questions to Anita while we are switching to Anthony, so we can come back to these questions if we have. So I would like to invite Anthony to make our third speech in our session. So Anthony, I think your slides are ready and we can share on the screen, and 20 minutes is yours, and of course, stage is yours, please.
Great. Thank you so much, and thank you for having me. I'm an attorney with Finnegan Henderson in Washington, D.C., and I'm happy to provide the U.S. perspective on some of the key patent cases that came out of last year. And as a bonus for the audience, I'm going to throw in one case from this year that just came out last month. And so specifically in this discussion, I want to cover two main topics, and we'll go through some different case examples within each of these topics. And so the first topic in the area of discussion that I want to address is the reach or the scope of forum selection clauses in contracts. And it comes up in our first case example here, which is a recent Federal Circuit decision in the United States of the Nippon Shinyaku versus Sarepta Therapeutics case. And in this case, the Federal Circuit took up the question of whether a forum selection clause within a contract could prevent a party of that contract from challenging a patent at the United States Patent and Trademark Office through an inter-parties review proceeding or IPR petitions. And so to cover some background on this case before I dive into the court's decision, the parties here, Nippon Shinyaku and Sarepta Therapeutics, entered into a confidentiality agreement. In the confidentiality agreement, the purpose of it was to discuss a potential business relationship relating to discovering therapies and treatments for a disorder called Duchenne's muscular dystrophy, which is a severe genetic disorder that causes progressive muscle deterioration and weakness, primarily in young men. And so at the center of this case, the courts are focusing on two different clauses within this contract between the parties here. And there is a covenant not to sue clause, and there was a forum selection clause. And so let me dive into the covenant not to sue clause, or the covenant term clause here, which that clause prohibited either party from bringing any action or cause of action relating to the intellectual property in the field of the invention, in the field of Duchenne muscular dystrophy. And taking a closer look at this covenant not to sue clause, it continued for clarity that the covenant not to sue included any patent validity challenges before the United States Patent and Trademark Office. But this covenant not to sue clause was time limited, so it was set to expire after a certain period of time. And once that covenant term concluded or expired, there was a forum selection clause that then governed. It governed for a period of 2 years after that covenant term expired. And so the forum selection clause, as we can see here, stated that all potential actions arising under U.S. law relating to patent infringement or invalidity shall be filed or brought in Delaware, in the district court for the District of Delaware in the United States. And that all potential actions term in the forum selection clause was actually defined by the agreement to include any intellectual property disputes that were filed with a court or with an administrative agency. So what happened in this case? What happened was when the covenant term expired, as I mentioned, on that day, Sarepta filed 7 IPR petitions with the United States Patent and Trademark Office, each challenging the validity of Nippon Shinyaku's patents. And so Nippon Shinyaku responded by suing Sarepta in Delaware for breach of this confidentiality agreement, among other things. And including in its filings, it asked the district court and the judge in Delaware for a preliminary injunction, asking the judge to order Sarepta to withdraw its IPR petitions from the United States Patent and Trademark Office. And so what did the district court do? The district court denied Nippon Shinyaku's motion, finding that the form selection clause here didn't actually cover the IPR petitions and whether they could be filed at the USPTO. It kind of walked through the contract and explained that there was an apparent disconnect between the covenant not to sue clause and the forum selection clause. And it found that, there's tension there because the covenant not to sue clause expressly identified IPRs or IPR petitions and not being able to file those. And then it would be odd that the form selection clause didn't expressly state anything about IPR filings. So the court determined that, it would be odd to expressly defer filing IPR petitions during this covenant not to sue period, but then during the form selection to, impliedly defer IPRs for another 2 years when the parties could have made that express. And so that's how the district court read that agreement. And on appeal, the Federal Circuit looked at the same agreement and actually overturned the decision from the district court. And the Federal Circuit read the plain language of that form selection clause as requiring the parties to bring all disputes regarding invalidity in the District of Delaware. And it found that, reading the definition of the all potential actions there, that specifically included actions filed with administrative agencies, of which the USPTO, the United States Patent and Trademark Office, is an administrative agency. It continued that, unlike the district court, it found that there actually wasn't a conflict between these two clauses, and they worked in parallel because the covenant not to sue clause was actually prohibiting the parties from litigating any issues relating to the patents, regardless of where they were brought. They just were not able to litigate any intellectual property disputes for that period. And then when that expired and the forum selection clause came over, the parties were able to litigate some intellectual property disputes. It just governed where they could do that. And the Federal Circuit read that as you're able to bring your action, but it has to be in the District of Delaware. And so that's how the Federal Circuit came out, determining that the IPRs were not allowed to be brought at the USPTO, and the invalidity challenges had to be brought within Delaware. So what can we learn from this case? For one, we learned that the court here has made clear that parties are free to contractually negotiate away their rights to bring patent validity challenges or IPR petitions at administrative agencies like the United States Patent and Trademark Office. So going forward, it's going to be really important for companies to carefully consider the scope of any forum selection clauses or any potential restrictions on patent infringement or invalidity actions in their agreements, covering confidentiality agreements like what was at issue in this case, but also you can consider license agreements or other agreements that companies are entering into. Right. So that was topic number one, covering kind of whether forum selection clauses can bar invalidity challenges at administrative agencies. And so I want to go through a couple case examples in my second topic, which relates to the commercial activity's effect on patentability. And I'll have a couple case examples here. And so the first of those case examples is another Federal Circuit decision from the Sunoco Partners versus U.S. Ventures case. And this case deals with the on-sale bar defense. And so the on-sale bar defense is a principle in U.S. patent law that prevents a person from obtaining a patent on an invention if that invention has been on sale more than 1 year before the patent's effective filing date. And so to prevail on this defense, an alleged infringer needs to show that the patented invention was both the subject of a commercial offer for sale and that that patented invention at that time was ready for patenting. And in this case, another important doctrine comes up, and that is the experimental use doctrine. And under the experimental use doctrine, a patent owner can use this doctrine to negate the on-sale bar defense by demonstrating that whatever sale occurred was actually primarily for the purposes of experimentation. And this experimental use doctrine draws a distinction between inventions put to experimental use and those products that are offered for commercial exploitation, commercial sale. And it's a balance of an inventor's interest in perfecting their invention, while at the same time limiting an inventor's attempt to use an invention for profit to make money before it's properly disclosed in a patent application. Okay, so what happened in this case? There was inventors at a company called MCE Blending that developed and filed patents directed to a system and method for blending butane with gasoline. And it did so, its system and method involved blending butane with gasoline at a time in the distribution process right before gasoline was put into tanker trucks and sent out to the gas stations. And it was important in this development because it increased gasoline volatility and would increase profits for the gasoline manufacturers because it decreased the cost of gasoline because butane is less expensive than the crude oil as I understand it. Right, but so more than 1 year before the inventors at MCE Blending or MCE filed its patent application on this new system, it entered into an agreement with one of its longstanding clients, Equilon, to install its blending butane system at Equilon's facility. Okay, and so fast forward quite a few years, Sunoco buys MCE and brings a patent infringement action against U.S. Ventures, asserting MCE's butane blending patent. And U.S. Ventures responded to this lawsuit, raising the on-sale bar defense. And as you can probably guess from my introduction of this case, Sunoco countered that defense by raising that this agreement was primarily for the purposes of experimentation, and therefore the on-sale bar, there was an exception to the on-sale bar. And so in the district court came out and agreed with Sunoco here, found that the contract was actually for experimental purposes, mainly because MCE did not charge Equilon any money to install its system at Equilon's facility. And so on appeal, what did the Federal Circuit do? The Federal Circuit, again, reversed the decision of the district court, finding that this early agreement between MCE and Equilon was actually a commercial sales agreement, and that it was not primarily for purposes of experimentation. And how did it come to this decision? It looked at the agreement itself and determined that the agreement was styled as a sales contract, and that MCE was using this technology for commercial exploitation. Specifically, it noted that MCE, while it didn't charge Equilon any amount of money to install its butane blending system or to transfer the butane blending system to Equilon, the agreement was still a sales contract because it required Equilon, as part of this agreement, to purchase, it was like 500,000 barrels of butane from MCE. So MCE was still making money on this agreement, even though the money wasn't required to pay for the blending system itself. The Federal Circuit also looked at the agreement and found that the contract stated that MCE had already developed rather than is developing the relevant technology and equipment. So, it kind of read the agreement and said, if this technology is already developed, then it probably is not for experimental purposes to refine that or to continue developing that technology. And another important factor here, it noted that in the agreement, it actually transferred the ownership and the title of all of the equipment to Equilon. So that was another indication for the Federal Circuit that this was actually a sales contract. And now there were a couple provisions within that sales contract that were regarding the equipment testing, and Sunoco and MCE were asserting that those equipment testing provisions showed that this contract really was for experimental purposes. And the Federal Circuit disagreed with that. It said that although there was certain clauses in there that required MCE to test this system, there was both pre-installation testing and post-installation testing that had to be done. The Federal Circuit thought that these testing provisions were really geared towards the satisfactory operation of the system. And so it went more towards ensuring that the system was installed properly and worked as promised under the agreement. And so, it again just confirmed that this was a contract for sale. So what can we take away from this case? From a litigation perspective, a business perspective, it's really important to cautiously consider any agreements where a company or you may be receiving some commercial benefit for the use of a technology that is not yet patented. Again, there's this trade-off in terms of a disclosure of your technology and putting your technology out into the public domain by filing a patent application and receiving the exclusivity of those rights. And so, you want to cautiously consider agreements where you may be commercially exploiting some technology before your patent applications have been filed. Okay, so let's look at the next case example here. In this case, the Junker versus Medical Components case also concerns the on-sale bar. So it's related. And the case here involves a design patent. And the design patent is for a handle for an introducer sheath, which I understand is primarily used for inserting a catheter into a patient's vein. And part of the design has these kind of how they described it as Mickey Mouse ears, which allows it's just easier for the doctor to kind of grab a hold of the introducer sheath and tear it away during this procedure. And so there was the inventor, Mr. Junker, came up with this design for this introducer sheath, and he employed the help of Mr. Edens to manufacture and supply his product. So he kind of came into a manufacturing and supply agreement with Mr. Edens. And so Mr. Junker's supplier here, Mr. Edens and Mr. Edens' company, began communicating with another company, Boston Scientific, about these introducer sheaths. And it sent Boston Scientific a detailed letter outlining the price and delivery options for varying sizes and bulk pricing for these introducer sheath products more than a year before the design patent here was filed. And so how did this case arise? Years later down the road, Mr. Junker sued Medical Components for infringement of this claim design. And you guessed it, Medical Components contended that this initial letter from Mr. Junker's supplier to Boston Scientific was actually a commercial offer for sale of the product embodying the claim design, and that it was it came more than a year before Mr. Junker filed his patent application. Therefore, the patent was invalid and Mr. Junker was not entitled to a design patent on his design. And so, upholding the patent's validity, the district court held that the letter from Mr. Junker's supplier was actually more of a preliminary negotiation with Boston Scientific, and it was not a definite offer. And so the court focused on the fact that the letter actually used the word that it was a quotation, and it concluded with an invitation to have further discussions with Boston Scientific regarding some specific requirements. So the patents are still valid, and the decision gets appealed. And the Federal Circuit here disagreed and reversed the district court's decision. And it looked primarily to contract law, which, using contract law informs us that any communication that rises to the level of a commercial offer for sale, well, it does rise to a level of a commercial offer for sale when one party could make that offer a binding contract just by simple acceptance, by saying, I agree, then the parties have a contract. And so the Federal Circuit, using this principle, looked at the actual letter, the actual language of the letter, and found that, yes, it did include the words quotation several times, but that itself was not controlling. Using the words quotation or preliminary negotiation may be helpful in this analysis, but it is not itself controlling, and instead looked to the letter more holistically. And it found that the letter was a commercial offer for sale because it was in direct response to Boston Scientific's request for a quotation, and it included many of the necessary terms that you would expect in a regular commercial contract. It included price terms for varying bulk size orders. It included the delivery terms. It included delivery conditions and so forth. And it further found that any reservation in the letter to further discussions with Boston Scientific regarding any requirements that Boston Scientific had was more a desire to continue to do business with Boston Scientific in the future, rather than an invitation to negotiate the offer. So again, taking away from this case, we can learn that in practice, it's often important that businesses carefully consider the commercial activity and any external discussions that they're having with outside parties surrounding the sale of technology that has not yet been disclosed in patent applications. Again, this ties back to the commercial exploitation of certain technologies before those technologies are disclosed in patent applications. All right, so let's turn to our last case example. As promised, this one came out just from last month. So it's actually a 2023 decision. And this one involves the public use bar. And similar to the on-sale bar that we were just discussing, the public use bar prevents a person from obtaining a patent. It prevents those patent rights if the invention was publicly used more than 1 year before the effective filing date of that patent application. And so the public use bar is triggered, as we can see here, if the patented invention was in public use, meaning that it was accessible to the public, and at that time it was ready for patenting. And that's usually shown by a working prototype or some enabling drawings or specifications that lay out the descriptions of the claimed technology. So let's dive into the facts here in the Minerva Surgical versus Hologic case. So here, Minerva asserted infringement of its patent that was directed to surgical devices for use in endometrial ablation, which is a procedure, as I understand it, for stopping and reducing uterine bleeding. And in this case, the defendants here raised the public use bar as a defense, contending that the patent, this 208 patent, was invalid because Minerva used its patented device at a public trade show. And in fact, the trade show that this device was used at was so popular and well attended in the industry that the defense actually called it the industry Super Bowl event because it was so widely attended. So we see here that the district court agreed with the defendants here and found that the claims were invalid under the public use bar because that device was displayed and demonstrated at this trade show more than a year before the patent application was filed. And it also found that the displayed devices embodied those asserted claims. So it was it covered the claims and it was ready for patenting based on the prototypes and the technical documents that were shown at the trade show. So on appeal, what did the Federal Circuit do? The Federal Circuit affirmed this decision, and it agreed with the district court's invalidity ruling. Specifically, it noted that the device that was shown to the public was shown without any limitations. Anyone could come to this trade show. There was no restrictions. There was no obligations of confidentiality in place at this show. Minerva was showcasing its device free and clear of any confidentiality obligations. The Federal Circuit also noted that beyond merely displaying the device at the booth, Minerva had done demonstrations and meetings with potential customers. It had hosted technical presentations demonstrating and showing the details of the device. And that level of detail concerning the disclosure was also an important factor here for the Federal Circuit. The Federal Circuit kind of suggested in their opinion that maybe showing a visual of a new design without disclosing the claimed technology, the nuts and bolts of it, may not be enough to invalidate a patent under the public use bar. But it found that under the facts here, it saw that Minerva's disclosure went far beyond that. It was far more detailed, and noted that Minerva was pitching the device to sophisticated industry members who knew how this device worked. Those industry members were able to come to the booth and scrutinize the device and see how it operated very closely. Even though those attendees were not allowed to physically handle the device, Minerva controlled the physical handling of the device itself. The close observations and the demonstrations here were enough to warrant the public use bar and were enough to invalidate the patent. So again, going forward, especially for industry events, it's really important for companies to carefully consider the confidentiality obligations and the level of inspection or the amount of detail and demonstrations that are done prior to filing and protecting those technologies and filing patent applications, right? And so that was, the two topics with 4 different case examples that I wanted to cover today. We talked about the form selection clauses and the reach of those form selection clauses, and then we finished with the discussion of the commercial impact and the exploitation of some technologies before those technologies are filed for patents. And so with that, I'll hand it over back to Mustafa and happily answer any questions.
Super exciting information, and it was really good examples, especially for the last one. I suppose that how is it possible to show the invention in Super Bowl event? But I reread again, and it was the industry's Super Bowl fair, I guess, a very important fair, and these cases are really important. But for the experimental, before switching to questions from the audience, for the experimental use case that you shared, what if they agreed on the agreement not purchasing the following items? So what if they just write down some clauses but non-binding and the pricing or no promise for purchasing for the following items? Would it be the same decision in that perspective?
Yeah, that's a really good question. And a lot of these a lot of these cases kind of come down to very factual determinations because you have to look at the contract in its entirety. You're looking at things holistically. But it seems like the underlying theme of a lot of these decisions from the court comes back to whether you are using your technology, whether you're using the unpatented technology before you file patent applications in a way that is, commercially exploiting that technology before it's disclosed, right? And that's what the courts here and the patent laws are trying to prevent. They want this trade-off of your disclosure and giving the public the right to access the invention to help innovation moving forward so people can build on each other. And the trade-off is you get the exclusivity and you have this term where you can commercially exploit. But if a company is trying to extend that term of commercial exploitation by trying to allocate funds or get money from business partners before that disclosure, that's generally not looked on very, very well.
I see. That's great. So thank you again, Anthony, and we are waiting for the questions and comments for you. Before waiting these questions, maybe we can turn back to the previous questions related with AI, which is a very hot topic. Preston, I want to give the stage to you again, because from Navami, she's asking that how will the nationality or address of an AI inventor identified?
My guess is as good as yours in this case. AI inventor by itself is a machine, and does the machine have a nationality? Well, it's all an open question. Does it have an address? At least what Dabo said, it had an address, and it was the address of the applicant because he owned that machine. So that's what was given. There was no nationality provided, at least what I can see at the EPO. But yeah, I'll be as curious as you are on this question by itself.
Okay. The next question is also about AI, but Anita and Anthony, you can also make your comments and give your answers. Özgür is saying that as it currently stands, both PCT and EPC, as well as the case law, have sections open to interpretation when it comes to the defining who the inventor is, let alone AI model generating ideas. This is the comment part. And the question is coming, do you think this will be handled differently in the future in a more fundamental way by updated rules and articles once the lawmakers become more familiar with the technology and its effects? What do you think?
Well, it was left a bit broad in EPC and PCT because it was up to the national laws to end up saying who the inventor questions are. So they thought, okay, let's leave it a little more broader because there might be questions in national law. Would they change it? Well, they have been raising questionnaire, requests for comments. I haven't seen any change happening. But of course, the question has been discussed. It's coming up. We just do not know when and how. And it's up to the national law to be changed. Unfortunately, as I said, EPC and PCT are an overarching body, and they probably have left it open just because they do not want to interfere with the national law to take care of how they individually want to define certain things.
That's right.
Yeah.
So, any comments from our other speakers for that question or the previous questions? If you want to make your inputs, feel free.
I was just looking at one of the comments which I previously provided apparently to what happens if you forget a name of inventor. Well, at least for the EPO, I know that you can change. Yeah.
This one?
Yeah.
Yeah. Okay.
I'm not an expert in US law. We have one here, of course, but I do not know if it's unremediable, uncorrigible, error if you miss out something or if it's corrigible at one point. Uh, at least for the EPO, we have a certain procedure going on, but I think I would leave. I would raise my hand for the US law. It could be uncorrigible error, but let's see
Yeah,
how that works. Yeah.
the it's a good question there. It's a good comment. You know, it's a lot more fact specific than that. With the key word in there is that you have to intentionally, you know, not name one of the inventors and kind of have a material representation with more of a malicious intent to kind of withhold that information from the patent office. Otherwise, most times it is a correctable issue.
Right. So I think we don't have any further comments or questions from the audience. Before closing our session, just 5 minutes or 4 or 5 minutes, I would like to share some of some notable patent cases, litigations, and licensing agreements from my point of view, because I'm more patent licensing and patent valuation oriented person and expertise. And if you don't mind, I will also share my topics from the news that I extracted, because these are details of these cases are more confidential. But first of all, is because in the COVID period, we had lots of patent litigation cases between vaccine producers, and the first one is CureVac has filed a patent infringement suit case against German-based company BioNTech. So that was one of the interesting patent infringement cases, because the CureVac was not filed this infringement for injection relief. So the BioNTech can continue distribute the vaccines in the market, but they want to reimburse their damage. And it was the same for the Moderna. Moderna is also filed a patent infringement suit against the Pfizer and BioNTech, which are partners in Germany and United States, basically for their mRNA vaccines technology. So this was also a very notable law case. And besides the COVID cases, and in the last few years, we are living a standard essential patents era in the world. So it means that all the connectivity patents are under attack. So one of the notable cases from my side is Nokia and Oppo are battling over their patents in the 3G, 4G, and 5G. So they're still going on. So this is one of the notable cases for the last year. So not for the connectivity, not only for the connectivity, of course, like this session, we are, and all of the communities are using live stream technologies. So as you know that Facebook changed its name as Meta, and Meta ordered to pay lots of millions of dollars to walkie-talkie app maker Voxer by using their live stream technology in the Instagram Live and Facebook Live. So this is one of the notable case that I noticed. So not nowadays it is so popular, but cryptocurrencies were, and Bitcoin and blockchain technologies were so popular. It will be game changer as well, of course. But one of the most important cryptocurrency platform, Coinbase, was sued for a patent infringement over a crypto transfer technology. One of the interesting part of this infringement case is the patent owner has only one patent and sued Coinbase. And endless, infringement case between Apple and Qualcomm is going back 2017, if I am not wrong. So the last year we saw the invalidity cases from Apple to Qualcomm's patents, but they all rejected. So it was really important litigation case as well. Again, invalidity case, as Anthony shared. And some of patent licensing agreements between Ericsson and Apple was signed last year. It was so exciting to see that. So Ericsson will ask so many royalties, it means. And the second case is another licensing, but cross-licensing agreement between Huawei and Oppo on, again, standard essential patents. We don't know the financial details about the royalties, but if we look at the previous explanations from the Huawei, they are willing to asking $2.5 per device for their standard essential patents. Maybe in this agreement, they also ask similar prices to Oppo. And not for litigation, not about the licensing agreements, it's all about ranking issue for the last year. The first time ever IBM was ranked in the second position in terms of US granted patents. So the Samsung now is ranked in the first position in the US granted US patents. And the last two, Espasnet has reached 140 million patent documents in the database. It was another milestone for our patent community for the last year. And as a last point, in parallel with the meaning of today, according to the EPO report, the proportion of the women inventors is increasing in the last years. And in that manner, I would like to celebrate and congratulate all the International Women Days, all of our women audience and women participants in all around the world. So these are my cases that I would like to share after your very valuable speech to combine and to overcome some of the other parts in the meaning of magazine from the patent world, let's say. So I'm looking to the comments, and Anushri Campbell is saying that excellent session. Arne Kruger is thank you very much for the great session. Thank you also, Arne, for your contributions. And Preston, Anita, Anthony, it was my pleasure to host you in our first episode of Patent Insights, powered by depa.tech and Moving Targets Consulting. And if you have any comments or remarks before closing, I can turn back to you.
No comments or remarks. Just thank you very much for having me.
Thank you, Anthony. Thank you.
Yes, echoing the same feedback. Thank you very much. A very good session.
Too many more sessions.
Thank you so much. So it will be bi-weekly, and maybe for the upcoming sessions, I will invite you again on different topics. So thank you again, and also thank you to our audience to listening our episode, the first one ever we did as a Patent Insight. And one announcement that we are publishing our patent barometer in Germany 2022. So it means that we are publishing all the patent statistics, patent landscape findings, and the patent-based startups, the funding rounds, and also commercialization information about Germany for the last year. So it will be published in the mid of May, so you can follow and you can download when it is published. So don't forget to join our depa.tech newsletter. And that was the last announcement before closing. So thank you again for our speakers and audience, and see you in the upcoming episodes of Patent Insights. Have a nice evening or day, wherever you are.
Thank you.
See you then.
Many, many thanks.
Thank you so much.